Hello, YouTube. I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We have a question here from YouTube user Monica A, who asked us, "What if your attorney agrees to a settlement offer without your consent? Would that be a breach of contract?" It would probably not be a breach of contract, but it would be a potential claim against your employment attorney. So, one of the things that we deal with in this industry and that I've been, chasing around for 11 years is that young employment attorneys love to believe their clients, which is a good thing, 9 times out of 10. But what you'll see is a client will say, they'll be going back and forth. The client was like, "Oh, I would take 110,000." Just like a verbal statement or even like a phone call, whatever it is. "I would take 110,000." And that young attorney will be like, "Cool, yeah, I'll go do that for you." And then they'll just go and do it. They'll just go and call up the other side and be like, "I accept your 110,000. We have a deal." And that might be a nice result, and that client might be happy. But here's what often happens. Very often. This is something that happens to human beings. I'm not shitting on clients here. This is just something that happens. So that person who said, "I will take 110,000," that client will go and improperly, because they're not supposed to tell their friends, but they'll go to their friends and they'll say, "I just settled my case for 110,000. I'm so happy." And their friends will be like, "That's not money. You're stupid. You did a stupid thing, blah, 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 blah." And immediately that client will be like, "What do you mean? What do you mean I did a stupid thing?" And of course, their friends have no flippant idea what they're talking about. They don't know the facts of the case. They haven't had a realistic explanation of what's going on. They don't know what the claims are. They don't know what the law says. They don't know what the witnesses are, what the evidence is. They're just some moron out there being like, "You shouldn't have done that. You're stupid. You're so stupid," right? I'm like this. These are the kind of things that you see, and it happens at all levels, right? If I'm like, "Oh, blah, 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 this guy owed me 50 grand and I settled, just be done with it. I took 30. People in my life will be like, "That's dumb. You shouldn't have done that." And it's like, no, it's not dumb. I calculated the value of my time, the risks, I hedged for risk, took into account the strengths and weaknesses of my case, the expense of proceeding forward. It's a totality of the circumstances decision with lots of variables, lots of moving pieces. So if somebody just says, "Oh, I settled my case," and your immediate response is, "You should have held out for more," probably that's a dumb immediate response, because probably you need to take a beat and think about the fact that you don't know what you're talking about. You don't practice in this field. You don't know what the evidence is. You don't know what the witnesses were. You don't know the issues with the case. You don't know the risks. You know the judge. You don't know who the jury is. You know what the jury pool is. There's so many issues that you don't know about, but it happens routinely. And when it happens, that client who said, "Oh, young attorney, I'll settle my case for 110,000," will come back and be like, "Oh, why would you settle my case for 110,000?" And the young attorney will be like, "What do you mean? I'm so happy I got what you wanted. It's what you wanted." And that client will say, "No, I never said that." And they might even believe they never said it, because everybody made fun of them when they got embarrassed. They were like, "I didn't say that. I definitely didn't say it. I wouldn't say that. I'm not dumb. Why would I say that?" Only a dumb person would say it. I didn't say that. And this happens to human beings a lot. And I think 70% of those human beings believe they didn't say it. The other 30% are just liars, right? And these young attorneys will be like, "Well, I did what you told me. I got you what you wanted. This is what you said you wanted. I won for you. I'm happy. I'm happy I did what you wanted." And the client's like, "I don't want that. You're a liar." This happens very commonly. To which the solution is, you only settle cases based on written authority. Only, ever. And any attorney who makes any departure in this field from that ever is fucking stupid and is committing an act of self-hate and self-harm. Also, it's just not best practices. It's not good for you. It's not good for your clients. It's terrible. And you will catch attorneys doing that like even late in their career. Like they'll do it correctly for 4 years in a row. And then one day they're like, no, this client's cool. They said this and I just did it. Like, okay, so you got stupid. You got stupid, attorney. You did everything right for 4 years, and then instead of taking 30 seconds to write one last email, one day, you decided to wake up and be stupid today. That's and like this is a big part of like managing a law firm, because hyper aggressive people will try to like not go through the checklist. They're like, oh, I'm a professional. I've been doing this a long time. I know what I'm doing. I know how to do it. They're like, no. We're going through our pre-flight checklist, just like the Air Force. We're going through our case settling checklist. Do you have a written statement from your client telling you what they want you to settle the case for? Oh, do you? Okay. Do you have that offer from opposing counsel? Oh, you do? Okay. So you have a meeting of the minds, client and employer, defendant, right? Have you thought about if that's a good deal for your client, right? Have you advised your client whether you think the client should take that or not? Have you had that discussion? You haven't? Why not? You just want to get the case done? Less work for you? That's dumb. Why would you skip that step? Why? You can have a conversation with your client. Listen, I think we can get you more. And the client might say, I get that and thank you for letting me know, but I do need this money now and I don't want any more risk or any more waiting, right? That's okay. You had the conversation. You can check your box in the checklist, right? It is essentially my frame of mind that if you catch an attorney settling cases without written authority, that attorney should just be fired. That attorney could be the most amazing litigator in the world, but they're now displaying an inability to engage in the checklist of best practices that our firm has developed and that other firms for 35 years developed before us in this field, right? Like, there's just things we know reduce the wear and tear on clients. There's things we know reduce the drama and conflict and horribleness of this industry. And those things are what we just call best practices. And there's lists of them. And you can go down them very, very carefully and say, yes, I have done that correctly. I have done the things I need to do to make sure my client's interests have been protected in this settlement. Check. Next line. I've done the things I need to do to make sure that my firm does not have exposure in this settlement when my client might someday decide that she or he wishes they had held out for more. Check. Right? And if you skip the box, you deserve what you get. Because you knew, people told you, people who've been there before were like, yeah, you got to do this. It's better for the client. It's better for you. It's really important. It must be done. And then you, because you're busy, skipped a 30-second email. No. You're useless now. You're useless as an attorney. You're not doing the things the way they should be done. Yeah, you might, listen, I'm still helping people. I'm bringing cases. I'm getting settlements. You're useless to me. You're useless to me. I don't want to be in conflict with my clients. Right? I don't know why you, the highly compensated attorney that you are, wouldn't do what you need to do to protect every ounce of the client and at the same time protect the firm. And ensure there's no conflict between firm and client, right? Client comes back to you and says, I didn't tell you to settle my case for 110. And this happens. The response ought to be, the fuck you didn't. Read this email you sent me, in which you told me specifically, yes, please, I want you to accept that offer for $110,000. I'd like payment in 28 days. Okay. We have a meeting of the minds. You wanted something, we delivered it. You're happy. You're not happy? I'm sorry. You told us what to do. We had to do it. because you are the shot caller client, right? So Monica A, I'm sure this is not what you're doing. You're describing a different thing, but I'm giving you the background of this specific issue in our field. I'm not saying that you told your client to settle the case for a certain amount and now you're lying or now you're confused or anything like that. I'm not saying that's what you're doing. This is the baseline. This is how these protections grew around this area because this is a significant issue. What it sounds like you're experiencing is a different issue where you hired an attorney and then you did not give them settlement authority. And then they settled the case. That I characterize as open malpractice. That is an ethical issue. It's a malpractice issue. And you probably need to speak to your local bar association about that in terms of a grievance and a fee dispute procedure. And you may, if you're being held to this settlement, if you're being forced to actually settle your case, even though you specifically never agreed to it because your attorney did, you may need to bring a malpractice claim against that attorney. And that attorney is going to be like, what do you mean? I helped you. I got you a good result. You didn't get the written authority, bro. You didn't do the basics. So you didn't help. You didn't help. Like if you're putting up, I don't know, siding on a house for somebody, and you go in, you're like, yeah, I'm gonna help you out. Free siding. Got you. And you put it up in a shitty way that makes problems later. Did you help? Did you? Not really. You didn't really help. Same things for the attorney. Oh, you helped? Okay, cool. Did you do it right? Or did you do it in a way that's probably going to make problems later? Oh, yeah? That's what you did? You didn't help. You didn't help. Right? I mean, sorry. This is I spend a significant portion of my life just talking about this with attorneys. Because this happens all the time. And certainly no one in our firm now, but like over the years, we've had talented attorneys who would like backslide on this. And it's just one of these things where it's like, hey, you do a good job, but there's a checklist for a reason. Do the checklist or you're done. Because the checklist protects the client, the checklist protects you. It's there for everyone. It's there to make this better. It's there to make you safe. It's there to protect your license, stupid. Don't be stupid. Like and it makes me mad, Monica A, when people do things like what they did to you here, right? Like if that attorney had a commitment to getting written settlement authority from you before settling your case, guess what they wouldn't have done? Settled your case without your specific agreement in writing, right? And now think of the nightmare you have in your hands. You got to go through an ethical issue with the bar association. You might have to bring a malpractice claim. There's a lot that you're going to have to do. They've made your life even harder. And it sounds like you already experienced a workplace sexual harassment or workplace discrimination issue, which is already really freaking hard. And this attorney made your life harder and maybe sold your claim out for less than it was worth without your agreement. Maybe not. Maybe the attorney got you an amazing deal and you just didn't want to agree to it. That happens too. That's your call, right? So, yeah, I get so fed up, and they'll look at you, these attorneys, they'll look at you and be like, no, I helped that person. Yeah? Do they know that? Do they know you helped them? Because if somebody's like, oh, I put siding in your house, and you're like, I didn't want that siding. You didn't help them. At least they don't think you helped. You're like, that siding's going to make your house last for years. You're better off with that siding. Cool. Still my house. Still my call. I didn't want the siding. You didn't help me because I didn't want the siding. You can say you know better than me, but guess what? It's not your house. It's not your case. Just because you got... Not your claim. You're the attorney, not the person who lived through it. Right? You can tell them, listen, this is a good deal because X, Y, and Z. Your case has lots of problems, lots of risk. The way the damages are calculated, this is a great deal. All valid things, and you could be right. You probably are right, frankly. But it's still not your claim. You're not the one who was attacked on the basis of her or his very identity. You didn't do that. And the attack didn't take the form of how you feed your children and put shelter over your head. Right? That's what we're talking about. That's what these claims are. Who you are at its core is why you're being attacked. And your ability to care for your loved ones and yourself is what's being attacked. And having a third party attorney tell you, yeah, I settled your case, you didn't get a say, is not okay. Never going to be okay. And any attorney who settles a case without written authority hates themselves and might hate their clients too, in my opinion. That is just how I feel about it. It's been a real issue over the years in my life. There was a period of time where I was like, I don't want to see a settlement agreement without a specific written authority from a client stapled to it. Like, if it's hitting my desk for my records from an attorney in my firm, that agreement better have the written authority from the client attached to it, permanently stapled. Oh, well, that's extra paperwork. Sure is. Do it. It's amazing. It's amazing. I'm tight with this client. We're cool. You ain't. Nah. They're not $500,000 cool. I'll tell you that right now. Client got $500,000. They think they're happy? Maybe. Give it 6 months. Oh, they spent $500,000 and they'd like a couple more? They're not happy anymore. Not because they're stupid. It's because they're human. You're representing human beings. And you too are a human being. And you know what? Verbal communication, it's not that clear. There are misunderstandings all the time. People half listen. People aren't sure what they said. There's 1,000,001 ways for that to go south on you. Get it in writing. Monica A., I'm sorry you have to deal with this. I hope that you were successful in unwinding that settlement if you don't want that settlement. I do not think it's a breach of contract issue, although I can see a couple of arguments why you would think that. And I mean, listen, check with local counsel. I don't know what state you're in. I don't know, the laws of where you are. Talking in generalities here. I'm talking as if your case was in New York, right? This is a 20-minute video. I made a 20-minute video ranting about this. If this was helpful, please like, subscribe, and comment down below. It helps me to help more people just like you. Remember, almost everybody works. Not everybody wins. Take care.